Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing sports stars, sexual assault, and non-disclosure agreements. There have been multiple news stories recently about sexual assault allegations against sports stars, including stars that are members of Hockey Canada's organization, which is Canada's governing body of hockey, which is currently under intense scrutiny for its handling of a sexual assault allegation against members of the previous men's junior teams. In the NFL, Cleveland's starting quarterback has been suspended for 11 games in order to pay a $5 million fine and undergo mandatory counseling after he was accused of sexual harassment by 24 women. One thing both these cases have in common is something called a non-disclosure agreement, or an NDA. In the wake of these scandals, some advocates are calling for the use of NDAs to be banned or restricted. Others argue that NDAs allow for victims to gain far more compensation than they would otherwise be able to get, which helps them get back on their feet. Here today to discuss the issue of sexual assault and NDAs are three experts, but we will first be joined by Rob Talak, the lawyer representing the victim in the Hockey Canada case. Rob, thanks so much for joining today. I want to start by asking how your client is doing. This issue has obviously gotten a lot of media attention. So how is she?
It's been difficult. I mean, I think she would love this all to go away, but there is, as we'll get into, a public interest in discussing some aspects of this.
So what can you tell me about the background of this particular case involving your client and some athletes with Hockey Canada? What exactly were the allegations?
So for anyone that hasn't looked at their phone in the last 2 months, this arises from the men's junior team gala dinner in London, Ontario, back in June of 2018. She ended up back in a hotel with a number of those players where, she has since alleged that quite a sexual debauchery took place. And, she went to the police shortly after that, an investigation that did not lead anywhere, and ultimately sued earlier this year, and that was resolved in May.
So there have not been any things that have been proven in court at this time. Is that correct?
That's right, and that's why I focused on the word allegations, because the lawsuit was settled very early, and shockingly early, in fact. And the police did not find any wrongdoing initially, though it is very clear they've now reopened the investigation.
So is there still a possibility then of charges being laid if the police investigation's been reopened?
I mean, I think there is. Some may say I'm an optimist, but the reality is I think the initial investigation had a very black and white, simplistic look of consent, where it is a much more complex legal issue, as we may get into.
So originally, Hockey Canada, when this settled, had a non-disclosure agreement with your client. What exactly did that NDA cover?
Well, it wasn't exactly an NDA because it was a communication plan, which is agreed to between the parties. I mean, my client wanted nothing to do with media. So, we had a little statement drawn up that everyone was content with if media were to come upon the case, which they did shortly after. But as the sun and light shone on this, I think Hockey Canada realized the right thing to do was to lift that communication plan entirely, and that's the situation today.
So what exactly did they say around lifting that communications plan? Why did they come to that decision?
Well, I don't know their thinking, but I know my thinking was, as players were starting to leak, or the lawyers were starting to leak, this was immediately following the disclosure of video and text to the Globe and Mail. It seemed like, we had one arm tied behind our back to respond because of the communication plan. So, I think the same day I was thinking we need to address this, they reached out on their own and said, we're going to lift it. So, you're able to respond to what's going on in the media.
And just for greater clarity, the existence of this communications plan, or even if it had been an NDA, a non-disclosure agreement, that would not have prevented your client from going to the police after if she had wanted to do that. Is that how it works?
Yeah, that's very important to know, Christine, is that no NDA in Canada or the US can prevent you from going to authorities, to police, to any government agency or body. And it typically also can't prevent you from seeking medical assistance and, speaking of your trauma, to a counselor. And oftentimes it also allows you latitude with family. So, the tightest NDA you can get is not absolute
Right.
as we sit here today.
Right. We've got to go to commercial break, but we'll continue this conversation when we come back. Welcome back to Canadian Justice, where we are discussing sports stars' sexual assault and non-disclosure agreements, including the recent scandal with Hockey Canada. So, Rob, my understanding is that since this story broke, there's been a lot of new information about other allegations of sexual assault or misconduct relating to Hockey Canada. What do you know about those other cases, how many there were, and the role that non-disclosure agreements might have played in those other cases?
I mean, I know that they're out east in Nova Scotia. There's another case that's opened up again about a Hockey Canada Championship team. But I mean, for me personally, having dealt with this for 20 years, sports has been an issue, but there's other institutions which have been much bigger issues. And I was really surprised by the interest that was taken on with respect to hockey.
Why do you think that is? I mean, sexual assault and sexual abuse is not limited to the realm of sports or entertainment. Why do you think the fascination in this particular case, which of course the facts are quite shocking of this particular case, but sports in general seems to attract more attention than other areas, even though sexual abuse is not limited to just one area?
Yeah, I mean, I deal with a lot of religious institution cases, but I think in Canada we can say that our national religion is hockey. Everybody has some connection to hockey, either as a fan or a former player. Or, every town has an arena. So I think that really, people can either see themselves as the victim or as a member of a team. And, it really just struck a chord with Canadians.
And I think part of what might have upset so many people was the role that ticket sales seemed to play in this case and in this scandal. What can you tell me about that?
Well, there's an issue about Hockey Canada keeping a reserve fund to help settle these things. I mean, I'm a bit on the other side on that. I thought that was responsible of them. I deal with many institutions that never, save for a rainy day. And then we have victims trying to get money from, an empty purse. The situation in the Archdiocese of St. John's is a perfect example. These are victims that will probably not be fully compensated because no one was responsible enough. But I get it. The average citizen and the average fan was saying, like, nobody told me a portion of my ticket sales or my kids' subscription sales, my kids' fees is going to a slush fund for sex abuse.
I certainly understand why people might feel that way as well. Do you think that this comes down to an organizational problem within the culture of Hockey Canada, or do you think that this sort of thing is a problem in all kinds of different institutions and large organizations? Or do you think there's something specific about what Hockey Canada was doing?
I think it's more cultural to the sport than to the institution. I mean, I grew up in a hockey town, Chatham, Ontario. I think a lot of listeners, viewers have had exposure to hockey. I mean, we worship these kids. We put them on a pedestal. We make excuses and exceptions for them. And this is the result. So, I mean, we need to dial down the celebrity worship, especially in sports. And we need to, Hockey Canada, or all of us, need to take some proactive steps to really, dent this culture in hockey. I've dealt with all kinds of institutions. I've never seen this level of debauchery in others.
What has been the fallout to the organization from this case? I know there has been some talk of forcing a change in leadership. What's going on there?
I mean, I think they're feeling the pressure that everyone feels, but, there's a lot of things Hockey Canada did right in this as well as did wrong. I have to be balanced and say, their early and painless settlement to my client was very appreciated, the flexibility on communication plans. But I think it's down at the arena grassroots level where we really need to address this. They have the mechanism to do that, but all of us as Canadians and all as hockey parents, we have the ability to influence as well.
And, do you think that in this case there was an NDA or a communications plan? Do you think that that was more because of the sort of high profile, almost celebrity culture around hockey players? Or do you think that that is something that's really consistently applied in all kinds of different industries when there's sexual abuse allegations.
No, I think the celebrity contributed to it. I mean, in reality, having done sex abuse cases, for approaching 2 decades, it's really a past thing, NDAs. We really don't see them that much, maybe with the exception on the quantum, the amount, but a lot of institutions and a lot of, defendants have accepted that is not going to be acceptable or appropriate in today's day. So I think when there's celebrity, and that's my experience, there's a lot more riding on a name. So the confidentiality holds a value.
When we come back from this commercial break, we're going to discuss the issue of NDAs as a legal instrument in further detail. We're going to be joined by two other experts. Welcome back to Canadian Justice, where we're discussing sports stars' sexual assault and non-disclosure agreements. We're now also joined by two legal experts on this topic. Julie McFarlane is a professor at the University of Windsor School of Law and co-founder of Can't Buy My Silence. And Howard Levitt is a Toronto-based lawyer with Levitt Sheik. Howard has a conflict in the Hockey Canada dispute and cannot comment directly on that case, so we'll focus mostly on the issue of non-disclosure agreements. Professor McFarlane, I'll start with you. You have been a vocal critic of the use of NDAs in sexual abuse cases, and you founded the organization Can't Buy My Silence, which campaigns to end the use of NDAs in those cases. So can you explain your position to us?
Yes, thank you, Christine. And can I just make a correction right away? I am no longer a professor at the University of Windsor Faculty of Law. I resigned my position in disgust at their use of NDAs in relation to someone who was a danger to students. And that's why I have founded Can't Buy My Silence with Zelda Perkins, who you may recognize. Her name was the first woman to break her Harvey Weinstein NDA. She is the UK side of the operation. I am the Canadian side of the operation. And I also want to clarify, although we are talking here about the use of non-disclosure agreements in cases involving sexual abuse or sexual assault, in fact, the campaign is interested in a much wider misuse of NDAs than that, because these are now absolutely epidemic in workplace settings. We have research, multiple sources of research now, showing that approximately 1 in every 3 employees has signed some kind of an NDA. And typically, Christine, what happens is you come forward with a complaint about sexual harassment, about discrimination of many, many kinds, about perhaps abuse or bullying in the workplace. And in response to your complaint, you receive a severance agreement. And as I will demonstrate in response to what I'm sure Howard's going to say, a pitifully small severance agreement in most cases, plus a non-disclosure agreement. So these have become the default now for dealing with workplace complaints, but also many other kinds of civil complaints. And I'm happy to give many other shocking examples.
Now, Mr. Levitt, you have negotiated hundreds of non-disclosure agreements, and I'm sure you have a very different perspective on them. So why don't you share it with us? What is your perspective on the role of NDAs in sexual abuse cases and in the other types of cases that Julie described?
Well, my perspective is that Julie's perspective punishes the victims. And when an employee comes to see me and I negotiate $1 million settlement or a $2 million settlement or a $3 million settlement, not a pitifully small severance settlement, the severance value of that case might be 10% of what we negotiate. And the other 90% is for the NDA, because the company has done something embarrassing to that company, something that's going to damage that company's brand, something they might have to make sure no one finds out about, and they're prepared to pay for that. And so the woman or man in question gets real compensation. And if they did not sign an NDA, there'd be no value in it for the company. They paid them the wrongful dismissal damage, which is a pitiful portion of the negotiation that I obtained for these victims. So re-victimizing them if they weren't able to get an NDA.
Christine, I need to get in here because I'm afraid that what Howard is saying, and I know he said this many times before, is completely unsupported by the facts. We have data that shows that most of these settlements are for extremely small amounts. We're talking about sexual harassment and discrimination and bullying within what is usually a precarious, marginally stable and poorly paid industry. For example, this kind of behavior, as I'm sure everybody listening must realize, is endemic in industries like hospitality, accommodations, retail, and so forth. So not even thinking about sports organizations now. Yet those workers, when they make a settlement, they are being compensated for what was done to them, the harm that was done to them. But we have data that shows that, for example, for pregnancy discrimination, 20% of people get less than $5,000 in those cases. In sexual harassment cases, we have data from the US showing that the average settlement for sexual harassment in the US, and this is the Employment Opportunities Commission, Howard, this is real facts, not just blustering, the average settlement is $25,000. And to say that people are only getting money and you can get them $1 million if there's going to be silence is just not true. Even if it was true, I think that most people would feel that covering up a perpetrator and allowing them to continue to do what they've already done over and over again is
Professor
an immoral
McFarlane,
thing to be facilitating.
A hot topic. We've got to go to break, but we will continue this after. Welcome back to Canadian Justice, where we're discussing the role of non-disclosure agreements in sexual abuse cases, discrimination cases, and in all kinds of areas where settlements are reached. Rob, why don't you tell us your view on the role of NDAs in cases of sexual abuse and assault in particular, and then we'll turn to Howard to respond to you and to what Professor McFarlane said in the last segment.
Yeah, well, let me start by saying Howard must be a much better lawyer than me because those numbers he was talking about, I don't see, even in cases of rape and things like that. So those are astronomical numbers for workplace. I'm taken back by that. So, I probably lean more with Julie on these are usually minuscule numbers. I think, in short, NDAs should be highly restricted, and they should be highly restricted in cases of any wrongful conduct, criminal torts, any misconduct in the workplace. Now, there needs to be exceptions because Julie, as a professor of law, and Howard, as a law practitioner, knows there's an exception to every rule. So, modeling the PEI Act, Prince Edward Island has tackled this. I think there needs to be almost a argument you have to make before a judge to justify one of these, and otherwise they're off the table. So that's where I stand on this.
Howard, why don't you respond to that? And if you want to respond to anything from the last segment as well.
Well, first of all, if you're before a judge, then the NDA doesn't matter anyway. But you won't get before a judge if there's an NDA unless there's something else ancillary that creates a legal issue. But you can't be before a judge if you've signed an NDA because the case is settled. But quite apart from that, what Julie said is, with respect, absolute nonsense. Maybe because she doesn't practice law, which I do. I act for employers and employees. And I can tell you on both sides, and whether it's $100,000 or $1 million, if a person has done something that's embarrassing to the company will pay for that. And they'll pay dramatically more than the case is worth. And I get settlements in the hundreds of thousands or millions regularly when we're dealing with significant executives generally, and they have brand damaging behavior against that particular company, and the company pays for that resolution. If you went to court and sued and just got wrongful dismissal damages, you get a fraction of the settlements that are negotiated on both sides.
Julie,
we might be talking about are the standard NDAs that are put into most release agreements, and frankly, the company doesn't care if they talk or not particularly. That's not the NDAs I'm talking about. I'm talking about really embarrassing behavior that will damage that company's brand, and therefore more is paid far above what the company would pay for that particular damage, that particular employee.
Julie, do you want to respond to any of that? And in particular, I'm interested in the question of if we restrict the use of NDAs, which are voluntary, wouldn't that be punishing victims who don't care about talking about the issue publicly? They don't want to. And it would be making them make the same choice as victims who do want to talk about it, and the potential risk to that is lower levels of compensation, which is Howard's argument. Do you want to respond to any of that?
Well, there are about 5 completely inaccurate pieces of information in that sentence, Christine. First of all, this isn't about victims talking publicly. NDAs, as Rob has explained, are about victims being allowed to talk to therapists, being allowed to talk to family, friends, co-workers. That's what this is about, not about victims going public. And in fact, we can protect victims with one-sided confidentiality and privacy clauses because that's exactly what they should have. But what's happening at the moment, and I want now to take this out of the stratosphere of these apparently million-dollar cases that Howard is negotiating all the time, because I've given you the data, and the data comes from very reliable sources. It doesn't say that at all. And the fact that I don't practice law has got nothing to do with it. I receive these documents every single day from people. The data shows us that people are being coerced into these agreements. And this is exactly why Rob referred to the PEI law, exactly why we are taking the approach we are. We are asking people to meet a whole series of conditions that ensures that these are not being used coercively and oppressively.
Right.
And I can tell you, Christine, that I have never talked to anybody who fully understood at the time they signed their NDA what it was going to mean for their life going forward,
Julie,
because it was a very pressured environment.
We've got to go. That's all the time we have. A very hot topic, but I want to thank you all for coming on to share your perspective.
For having us.
Thank you.
We've heard today about the story of the scandal surrounding Hockey Canada. What role do NDAs play? Do they enable abuse, or do they allow better compensation for victims? Should the law around them change, or is it doing its job? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.